in New Hampshire, but that's older, Your Honor. And I don't see it going back and forth. So it looks like she's been with us for a while. It's interesting here. They go in, they search some stuff. They're dealing with Mr. McNary, and they allow my client to leave, and then they go stop her. I think the focus of this investigation turns out to be Mr. Neri, and that if my client had anything, it might appear to be a small misdemeanor amount of possession of marijuana. I know there's been probable cause, but I'm just pointing out to the court that the moving party seems to be the co-defendant here, although arguably my client may have been present in the motel room, appeared to be in the process of leaving. My client advises me that she could continue to find board at the Econo Lodge where she had been for over the last 30 days. She hadn't been working at most recently at this point in time. So I would ask the court, given her lack of record, which I believe is one prior matter here, and then older stuff in New Hampshire, to consider reducing her bond to something like $2,000 that might get her to make sure she comes maybe even unsecured at that point. I would argue against the condition 11, which is a total curfew at whatever address she's able to supply to the court. There doesn't seem to be anything there that would increase the likelihood or not the likelihood of her showing up to court. And there's nothing here to indicate that she needs to stay at a particular location to be able to get herself to court. The other conditions I don't have an objection to. So I would ask the court to adopt the state's conditions except for the curfew one, reduce the bond potentially to $2,000 unsecured for my client. Thank you.
Thank you. All right. Well, in imposing bail, court can only impose bail if it's reasonably necessary to prevent flight to avoid prosecution. In making that determination, the court has to consider the factors under 13 Vermont statutes annotated section 7554, which the court will as follows. Court has to consider seriousness of the offenses charged, number of offenses, nature and circumstances of the offenses. So here we have a fentanyl trafficking charge and a fentanyl conspiracy charge. I'm not sure if in the end there'll be two different charges, but each carries a potential sentence of 30 years. Also, a misdemeanor possession of cocaine charge and obstruction of justice charge carries a potential sentence of 5 years. Court has to consider the weight of the evidence against the defendant. There's enough for probable cause. Court has to consider whether at the time of the current arrest or offense the defendant was released on conditions or probation. That is the case here. She was recently placed on conditions of probation. Court has to consider whether in connection with a criminal prosecution, defendant is compliant with court orders. The allegation certainly is she wasn't compliant with the terms of her probation by engaging in additional criminal activity. It has to consider defendant's record of appearance at court proceedings, flight to avoid prosecution, any record of failing to appear at court proceedings. Her record check does show one recent failure to appear for a court hearing on January 30th, 2026. Court has to consider defendant's character and mental condition. Court's not aware of anything
Explain
there.
that. Could you please explain why in this court, Your Honor? And this court because my apartment building, I had an apartment in Brattleboro, Vermont for the last 3 years. My apartment got condemned because of structural damage. I wasn't able to get mail and stuff, so I missed court on accident. As soon as I found out, I went and turned myself in.
Okay, that's helpful. Thank you. Court will accept that. Court has to consider defendant's employment, financial resource, ability to post bail. She's not employed, doesn't appear to have a significant ability to post bail. I haven't heard Attorney Bragdon, she has any family ties to the area or specifically how long she's resided in the community?
I don't reside in the community and I don't have ties to the community here, but that's the community in Brattleboro.
Let your attorney do the talking right now, ma'am.
So far, I'm going to repeat the same thing. She's been here for approximately 6 years, Your Honor, and she doesn't have any strong family ties here in our community.
Thank you. All right. Well, those are factors the court has to consider.
Attorney.
Am I audible?
Attorney Bianchi?
Can you hear me okay?
Yeah.
Okay, I'm sorry, and the court may have noticed this. I just wanted to point out that that in paragraph 8, she actually tried to leave the scene, but also that she has a record from not just New Hampshire, but also West Virginia. Those were
Okay.
just the 2 points that I wanted to court, if you had noticed.
Excuse me.
Just listen to the judge, please, at this point.
Okay, so the defendant doesn't have any significant family ties to the area. She's resided in the community for about 6 years, although she's listed as transient and is currently residing in the O'Connell Lodge in Bennington. Considering those factors, but in this case, most importantly, given the number of charges, the seriousness of the charges, the fact that she was already on probation at the time, court does find that she does present a significant risk of flight to avoid prosecution. Court also notes her lack of family ties to the area and somewhat tenuous ties to the area, residing at the O'Connell Lodge. Court does find that bailing amount $10,000 cash or surety is reasonably necessary to prevent flight to avoid prosecution, will impose bail in that amount, will otherwise impose conditions. 1, that she come to court as directed. 2, if her contact information changes, she'll let her attorney or the court clerk know right away. 13, shall not purchase, possess, use firearms or any dangerous or deadly weapons. 14, for no contact in any manner with Craig McNary, capital M, small c, capital N-A-R-Y, and 15, shall not abuse or harass Mr. McNary. That will be the order of the court. Now we'll do the VOP. Is the state looking for any conditions or bail on the VOP?
Your Honor, the one additional condition we would request is that Ms. Eklund appear at probation and parole and meet with them as soon as possible.
Yes, sir.
Okay. All right. In the VOP, court will just impose one condition, that she meet with her probation officer within the first business day of being released. That will be the order of the court. Thank you. Your attorneys will be in contact with you, Ms. Eklund.
Thank you.
That'll be Miss Bliss.
Thank you, sir.
And Attorney Bragdon, I believe that's all of the lodged folks for Rutland. Mr. Karen was on the list, but I believe that was a parole violation, so I don't think it needs to be heard. I just didn't want you to sit around waiting for that case.
Thank you, Jared, but I did see that everything's parole, but one of them was a continuation of probation, but I didn't see a VOP in it. So until I do, or just take it off for today.
So Judge Corsones, is it okay if we hop off? But if you discover that you need us, we're happy to rejoin. Is that okay?
Sure. Thanks.
Thank you.
Judge.
Yeah, you're welcome. Attorney Brooks, do you have any ready to go?
I do not, Your Honor.
Okay.
I'm here for a 145.
Okay. Anybody have any cases ready to go? Are you all waiting for an attorney? Sounds like you're waiting for, probably for Attorney Falcone when she's ready.
Got the floor, is that what I heard?
Yes, you do.
Okay, great. We can call Bruce Taylor.
On the record, State versus Bruce Taylor Jr., 26 CR 3671. Mr. Taylor's here with Attorney Falcone, Attorney Olson for the state. We are here for an arraignment. Go ahead, Attorney Falcone.
Thank you. We are in receipt of the 2-count information affidavit. We waive formal reading of the charges of Rule 5 advisements in the 24-hour rule. Enter a not guilty plea to the charges.
Olson, state looking for conditions or bail?
Yes, sorry, Judge. There's a few things I need to address, and I need to make sure that I sent this to Attorney Falcone. The state is going to be dismissing count 2 without prejudice based off of new information that the state learned in this information.
Okay.
The state, as it relates to non-monetary conditions of release, is looking for condition 1, 2, 12, 14, and a 15 as it relates to Virginia Stevens, including a 300-foot restriction. We are not asking for a condition 16 as it relates to the information, and we were asking for a condition 19 and a pretrial services order. We are asking for bail in the amount of $1,000 remain in place, Your Honor. In support thereof, the state's pointing to the probable cause or the probable cause affidavit, specifically that when law enforcement arrived on scene, the defendant was not there and law enforcement wasn't able to locate him. Officer Rice did call him, spoke to the defendant on the phone, and he originally stated he refused to meet with Officer Rice because he knew he was going to be getting arrested. Eventually, he did turn himself in, but Your Honor, that coupled with, I believe he has, you have one moment. I believe the actions at least taken in the probable cause affidavit, Your Honor, we do believe he is a slight risk of flight from prosecution. And so we are asking for the $1,000 bail to remain in place that was imposed over the weekend.
Falco.
Thank you, Judge. We have no objection to the requested conditions. We do object to the imposition. Well, we would ask that the $1,000 bail that was posted last night be struck, as Mr. Taylor does not present a risk of flight to avoid prosecution. As stated by Attorney Olson, Mr. Taylor did go to speak with the officer after the officer called him. So even though he initially denied it, which is everybody's right to deny going to voluntarily speak with the police, he did voluntarily speak with them. He posted his bail. He's here today. He's a Vermont native. He's lived here his whole life. His whole family, social circle, everything is here. He is not regularly employed, although he does kind of side jobs. He receives Social Security disability, so he doesn't have a lot of disposable income to pay $1,000 bond. So if he can, if the court could strike that, given that he doesn't present a
Right, state's asking for bail. Court can only impose bail if reasonably necessary to prevent flight to avoid prosecution. In making that determination, the court has to consider the factors under 13 Vermont statutes annotated, section 7554, which the court will as follows. Court has to consider seriousness of the offense charged, number of offenses, nature and circumstances of the offense charged. Defendant's facing one serious charge. It's a second-degree aggravated domestic assault charge based upon a prior conviction. Court has to consider weight of the evidence against the defendant. There's enough for probable cause. Court has to consider whether at the time of the current offense or arrest, the defendant was released on conditions, probation, etc. That doesn't appear to be the case here. Court has to consider defendant's record of appearance at court proceedings, flight to avoid prosecution, any record of failing to appear at proceedings. According to his record check, he doesn't have any history of failing to appear for court proceedings or a flight to avoid prosecution. Court has to consider defendant's character and mental condition. Court's not aware of anything there that would go towards bail. Court has to consider defendant's employment, financial resource, ability to post bail. Does certainly have the ability to post $1,000 bail because he did post it. His income consists of disability payments. Defendant has strong family ties to the area and is a long-term resident of the community. But given his lack of history of failing to appear or a flight to avoid prosecution and strong ties to the area, court does not find that bail is reasonably necessary to prevent flight to avoid prosecution, will not impose bail in this case, and will release him on the agreed upon conditions. 1, come to court as directed. 2, if your contact information changes, you have to let your attorney or the court clerk know right away. 12, shall not purchase, possess, consume alcohol. 14, no contact in any manner with Virginia Stevens. No contact means no contact directly, in person, indirectly, through third parties, through any social media, Facebook, texting, phone, letters, etc. 15, shall not abuse or harass Ms. Stevens. Must remain 300 feet away from Ms. Stevens at all time. 19, subject to preliminary breath testing upon a reasonable request of a law enforcement officer. Any objection to a pretrial services order for alcohol or substances?
I said no objection, but we would decline pretrial services at this time.
Right, Mr. Taylor needs to sign for those conditions downstairs before he leaves. Follow those conditions carefully.
Right, thank you. You need to go downstairs and sign for your.
Hi, this is Judge Corsones. Is that Ms. Waldrug in the video room? Okay.
Yes.
We're on the record, State versus Victoria Waldrug, 26 CR 2698, 26 CR 2697. Ms. Waldrug was picked up on an arrest warrant based upon her failure to appear for her calendar call hearing on April 8th. So let me check with the state first, see if they are seeking a continuation of bail.
I'm sorry, Judge, I just
Yep.
have one moment. That's it. Let's see that then.
So actually, I'll take over. In speaking with Attorney Sun, we've come to an agreement by
Okay.
which Ms. Waldrug would plead guilty in 26 CR 2698 for 2 to 3 days to serve with credit for time served, and the other docket would be dismissed.
Ms. Waldrug, is that your understanding of the agreement?
Yeah,
And have you had enough time to go over this with your attorney?
yes,
So you're going to plead guilty to retail theft in 26 CR 2698. You're going to receive a sentence of 2 to 3 days to serve with credit for time served.
yes,
Does she have the full credit or will she
Yes,
get
he was picked up on Friday.
on Friday? Okay. And the other retail theft charge in 2697 will be dismissed. So Ms. Waldrug, you understand you don't have to plead guilty today if you don't want to. You do have the right to continue with your not guilty plea and to have a trial if that's what you want. Do you understand that?
yes,
You also have what we refer to as the right to remain silent, meaning you couldn't be forced to testify or give evidence against yourself. And you have the right to be represented by an attorney throughout these proceedings. And if you can't afford one, one will be provided to you by the state. Do you understand that?
yes,
If you continued with your not guilty plea, you'd be entitled to a trial. You could have a trial either in front of a 12-person jury or just in front of a judge. That would be your decision to make, but at any trial, the state would have to prove you guilty by beyond a reasonable doubt. And at a jury trial, all 12 jurors would have to unanimously agree on the verdict. You understand that you have those rights.
yes,
At a trial, you'd have the right to hear and see what the state's witnesses had to say and to have your attorney question them. You could also call witnesses to come to court to testify for your side. And if for any reason any of your witnesses did not want to come to court voluntarily, through your attorney, you could make sure they came to court and testified by having the court issue them a subpoena. Do you understand that?
yes,
At a trial, you would have the right to testify like any other witness, but as the defendant, you'd also have the right not to testify. And if you decided not to testify, then you wouldn't have to testify. You couldn't be forced to testify, and it could not be held against you in any way if you decided not to testify. You understand that you have that right.
yes,
In addition, you'd have the right to appeal any verdict to a higher court. In Vermont, that court's called the Vermont Supreme Court. Do you understand that you have that appeal right?
yes,
Any questions at all, Ms. Waldrug, about any of these rights that I have reviewed with you?
No.
Now, do you understand if you do plead guilty today, you'll be giving up these rights that I've gone over with you, including your right to a trial by jury, because there will be no further trial of any kind in your case?
yes,
Has anyone used any force or made any threats against you to get you to go along with this agreement?
No.
Has anyone made any promises to you to get you to do this other than what we've discussed today on the record?
no,
Doing this today voluntarily.
yes,
Need to ask, are you currently under the influence of alcohol, drugs, or prescription medication such that you do not understand these proceedings here today?
no,
Need to tell you that if you are not a U.S. citizen, this agreement could result in your deportation, denial of U.S. citizenship, or denial of re-entry into the country. That only applies if you're not a U.S. citizen, but do you understand that?
Yeah.
So now for the charge that you are pleading guilty to today, I need to review with you the maximum potential penalty, the nature of the charge, and the factual basis for the charge. So the maximum potential penalty for the charge of retail theft in excess of $250 and less than $900 is a term of imprisonment not more than 6 months or a fine of not more than $500 or both. Do you understand that?
Yes,
And the nature of the charge is that at Rutland City on or about February 15, 2026, with the intent of depriving the merchant wrongfully of the lawful possession of its merchandise, you took and carried away from the TJ Maxx store without paying for it, merchandise having a value of $492.75. Do you understand that?
yes,
And do you agree that you did do that?
yes,
To that charge, what plea do you wish to enter?
guilty.
Right, court will accept your guilty plea, find that there is a factual basis. Court will find that you've made your plea knowingly and voluntarily with full knowledge of its consequences, and that you've waived your constitutional rights, and the court will enter adjudication of guilt in this matter. Attorney Olson, anything further from the state? Do we know if the product was recovered?
One and then dismissal of the other. Okay, just wanted to make sure. Your Honor, this is fair and reasonable. The merchandise was completely
Okay,
found by law enforcement and returned to the merchant. I believe this is fair and appropriate, and I support to impose it.
thank you. Attorney Falcone?
I don't have anything further, Jim.
Ms. Waldrug, anything you want to tell me before I impose the sentence? Okay. Court finds this a fair and reasonable agreement. Will accept it in 26 CR 2698 retail theft. Court sentences Ms. Waldrug to 2 to 3 days to serve with credit for time served. 26 CR 2697 is dismissed with prejudice as a part of this plea agreement. So you're all set, Ms. Waldrug. You should be released once they get the paperwork and process everything.
Michael Lancaster.
On the record, State versus Michael Lancaster, 25 CR 342. Mr. Lancaster's here with Attorney Falcone, Attorney Olson for the state. We're here for an arraignment. Go ahead, Attorney Falcone.
Thank you, Judge. We are in receipt of the one count information accompanying the affidavit. We would waive former reading of the charge of Rule 5 advisements and the 24-hour rule. Enter a not guilty plea to the charge. There's no objection to the requested conditions on the information. We would ask that bail be struck.
And fine with striking bail, Your Honor, as long as we can do a condition 3, I believe, that he has to appear in person at his next court date, if we can get that to him. Right?
Yes, Your Honor. Again, can we, it looks like be a calendar call.
And if the court could authorize a remote appearance, that would be helpful. Mr. Lancaster does live in Barry.
Remote appearance.
Yeah.
Yep. Any objection from the
No
state?
objection, Judge.
All right, court will strike bail and release Mr. Lancaster on condition 1, that he come to court as directed. 2, if his contact information changes, he has to let his attorney or the court clerk know right away. 3, must participate in his calendar call hearing on May 15th at 2 p.m. Remote appearance is okay. 15, shall not abuse or harass Margaret and Edward Hackett in any manner. So you'll be released, but you need to sign for those conditions downstairs before you leave. Make sure you stay in contact with your attorney. And if your contact information changes, you have to let your attorney know right away.
Yes, sir. Thank you.
Yep, you're welcome.
Thanks, sir.
Thank you.
They could also. When
It's still good. Then I can call Matthew Poro.
State versus Matthew Poro, 26 CR 3672. Mr. Poro's here with Attorney Falcone, Attorney Olson for the state. We're here for an arraignment. Go ahead, Attorney Falcone.
Thank you, Judge. In receipt of the 2-count information affidavit, would waive formal reading of the charges of Rule 5 and the 24-hour rule. Enter not guilty.
Attorney Falcone, any requests? I'm sorry, Attorney Olson, any requests from the state?
Either way, Judge, we're requesting recognizance, but noting that all other conditions are still in full force and effect.
Thank you. So, Mr. Poro, we're not imposing any additional conditions, but The other conditions of release, including the no contact provision, remain in full force and effect. Otherwise, you're free to go. Okay, we'll be in recess till we are ready on our, well, let's go on the record in State versus Jeremy Mahoney, 26 CR 1158, scheduled for an attorney or peer hearing, but public defender has entered an appearance. So I think it got scheduled for an attorney or peer before we got public defender application. So that
That
could
should be
be,
assigned to me and Mr.
Okay. Okay, you can,
Let him know.
you can tell him he's all set. Just there was the notice went out before we got the public defender application. That's all. That's what happened. Thank you.
Much.
Okay. Only ones left, Stephen Williams and Heather Payne. Unclear if she's here. I think that was that woman sitting out. It could be, you want to take a look at that case. Okay. It also seems unclear if she was actually arrested and lodged.
So I think Keith Porter was from this morning, right? He show up? Is that why it's on?
I'll see what it's for.
Oh, okay.
Do you know who's representing Williams? Mark?
You ready to bring up Keith Porter?
Attorney, okay.
Oh, okay.
And I guess there's.
Thanks.
That's an arraignment from this morning. Yeah. That was just a retail theft, I think.
Thank you. No problem. I'm gonna handle this victim.
No.
Yeah. Good afternoon, Judge.
You as well, Attorney Olson. Thank you.
She is not ready for.
Okay. All right. We'll take a break.
Pretty good stuff. Pretty good stuff. 24-hour. I mean, look, man, the guy is quick. So good job. All right. So I appreciate that. Thank you for sharing that with me. I'm glad that I have in my community as someone that likes to do that as well. I can share that, and I like knowing that I can increase my squad, whatever you want to call it, you know. What's up, Brandon Mitchell? What's up? What's going on, BPR? What's happening? Brandon Mitchell in the house. Oh shit. Oh boy. I know there's been a lot of cases been going on. I know Sean is doing his case and whatnot he's got going on. I know Eli might have some cases going on, so I mean everybody's having it. You know? So let me finish what I was doing before I get distracted again. By the way, if anybody here has anything they want to promote, like any lives coming up, you're more than welcome to do it on my page. Any videos you guys want to premiere? No problem. Just do it while I am taking care of a little bit of business here. Case is oh shit. It's not good. Nope. Those are not good. Sorry to hear that. All right, give me a second here. I'm just taking care of a little business. Oh, doing a little gardening real quick. The new random Patriot video, the cops are lunatic. You know what? Let's watch it while we're here. I might as well give you guys something to watch while we're while I'm grinding some stuff here. So all right, give me a second. Let's pull it up. Let's pull it up. Let's pull it up. Patriot. All right, here we go. Let's watch. So he just did it an hour ago. Shout out to him, man. The guy's got 181 subscribers, 1,000 subscribers. That's what's up. All right, let's put this. Let's share. Let's watch this, guys. Let's take a look. Gotta love the broccoli. You know it, baby. You know it. All right, let's watch this. All right, let's put it up here. Thank you very much, man. Yeah. Guys, if you haven't subbed to him, go sub to him. All right, let's go in here. I'll just make it full screen. Of course not. Sometimes StreamYard gets on my damn mother loving nerves. All right. Let's try this again. Oh, my friend.
for an arraignment. Attorney Walco.
Falco, sorry. Yeah. We are in receipt of the state's one-count information affidavit. We'd waive formal reading of the charge of Rule 5 and the 24-hour rule. Mr. Porter has reached an agreement with the state whereby he would plead guilty to the one charge for a 0 to 1 day to serve sentence for credit for time served.
I mean, there's no restitution issue.
I believe all the merchandise was the.
Okay, very good.
It's my understanding, Judge.
Okay. So, Mr. Porter, I'm going to go over your rights with you as well as the agreement. Make sure you understand everything. If you do have any questions, speak up and let me know. And if you want to talk privately with Attorney Falcone at any time, feel free to do so. So my understanding is the agreement is you can plead guilty to the misdemeanor charge of retail theft. As a result of that guilty plea, you're going to receive a sentence of 0 to 1 day to serve with credit for 1 day served in the local lockup. Is that your understanding of the agreement?
Yes, sir.
Is that what you want to do today?
Yes, Your Honor.
You had enough time to go over this with your attorney?
Yes.
You understand you don't have to plead guilty today if you don't want to. You do have the right to enter and continue with a not guilty plea and to have a trial if that's what you want to do. Do you understand you have that right?
Yes.
You also have what we refer to as the right to remain silent, meaning you couldn't be forced to testify or give evidence against yourself. And you have the right to be represented by an attorney throughout these proceedings. And if you can't afford one, one will be provided to you by the state. You understand that?
Yes, I do.
At a trial, you'd have the right to hear and see what the state's witnesses had to say and to have your attorney question them. You could also call witnesses to come to court to testify for your side. And if for any reason any of your witnesses did not want to come to court voluntarily, through your attorney, you could make sure they came to court and testified by having the judge issue them a subpoena. You understand that?
Yes, I do.
If you continued with your not guilty plea, you'd be entitled to a trial. You could have a trial either in front of a 12-person jury or just in front of a judge. That would be your decision to make, but at any trial, the state would have to prove you guilty by beyond a reasonable doubt. And at a jury trial, all 12 jurors would have to unanimously agree on the verdict. Do you understand that?
I do.
At any trial, you'd have the right to testify like any other witness, but as the defendant, you'd also have the right not to testify. And if you decided not to testify, then you wouldn't have to testify. You couldn't be forced to testify, and it could not be held against you in any way if you decided not to testify. Do you understand? You have that right, Mr. Porter.
Yes, I do.
Also, you'd have the right to appeal any verdict to a higher court in Vermont. That's called the Vermont Supreme Court. Do you understand that you have that appeal right? Any questions at all about any of these rights that I've gone over with you?
No.
Now, do you understand if you do plead guilty today, you'll be giving up these rights that I've gone over with you, including your right to a trial by jury, because there will be no further trial of any kind in your case?
Yes.
Has anyone used any force or made any threats against you to get you to go along with this agreement?
No.
Has anyone made any promises to you to get you to do this other than what we've discussed today on the record?
No.
Are you doing this today voluntarily?
Yes, I am.
Need to ask, are you currently under the influence of alcohol, drugs, or prescription medication such that you do not understand these proceedings here today?
No.
Need to tell you that if you are not a U.S. citizen, this agreement could result in your deportation, denial of U.S. citizenship, or denial of re-entry into the country, okay? The maximum potential penalty for this misdemeanor charge of retail theft is a term of imprisonment of not more than 30 days or a fine of not more than $500 or both. Do you understand that?
Yeah.
And the nature of the charge is that at Rutland City on or about March 13, 2026, with the intent of depriving the merchant wrongfully of the lawful possession of its merchandise, you took and carried away merchandise from the Grand Union store without paying for it. Do you understand that?
Yes.
And do you agree that you did do that?
I did.
To that charge, what plea do you wish to enter?
Guilty.
The court will accept your guilty plea, find that there is a factual basis. Court will find that you've made your plea knowingly and voluntarily with full knowledge of its consequences, and that you've waived your constitutional rights. The court will enter adjudication of guilt in this matter. Attorney Walco, anything further from the state?
Nothing further, Judge.
Attorney Falcone, anything further from the defense?
I-
Mr. Porter, anything you want to tell me before I impose a sentence?
No, Your Honor.
Okay, based on the facts and circumstances present, court finds this a fair and reasonable agreement. Will sentence Mr. Porter to 0 to 1 day to serve with credit for time served. So You'll be released. Bail is struck. Just need to check in at the downstairs window before you leave. There are some surcharges they have to talk to you about.
Okay.
Okay, have a good day.
Thank you very much.
Thank you.
Would like us, okay?
Yeah.
Okay, let me, okay. You here on Williams? Okay.
Carolyn?
We'll have Stephen Williams here shortly.
Okay, very good. See downstairs? Okay. On the record, State versus Stephen Williams. We have three separate cases. Dalton robbery with injury, 26 CR 1549. Aggravated operation without owner's consent, 26 CR 1743. Petty larceny, 25 CR 14005. Mr. Williams is here with Attorney Ferland, Attorney Walco for the state. Attorney Ferland.
Judge, so we are in receipt of the three one-count informations and the affidavits. We'll waive formal reading, 24-hour waiting period, other Rule 5 formalities. Enter a plea on Mr. Williams' behalf of not guilty. Judge, we're not contesting the without today.
State's looking for hold without bail in 26 CR 1549.
Yes, Judge, the state would be requesting the hold without bail as well as the defendant to be held pending the weight of the evidence hearing.
All right, that's not being contested at this time, so the court will hold the defendant without bail pending weight of the evidence hearing. We'll schedule 1 hour, be sufficient for a weight of the evidence hearing as best we can tell now.
I think that's really more up to the state. I don't know if they're
Yeah.
rely on video. I mean, there is an audio recording reference in the affidavit. I think
I don't remember how
a
long.
lot of witnesses. I don't know what.
Judge, I'd ask for 2 hours at this time, and I will speak with Attorney Sullivan, and if he does
Okay.
require more time, he can inform.
Okay, so we'll set it for a 2 hour wait of the evidence hearing. Is the state looking for any conditions in the other cases? So the
Judge, if I could just have one moment on,
the OOC and the information says 1, 2, and 14 and 15 for Brian Ingerson.
yes, Judge, that is correct on that case.
Any objection to those conditions, Attorney Ferlin? No. Okay, it'll be released on those conditions in that case.
Yep.
And petty larceny, was there anything?
And that's 25, CR 140005.
Looks like it was also a 14, 15, and a 16.
Yes, Judge, that's accurate.
Oh,
I think it's 50 West Street in Fairhaven, Nicole Fredette.
okay. So condition 16 for 50 West Street in Fairhaven, and no contact with Nicole Fredette. 15 for Nicole Fredette and 1 and 2. Thank you.
Thank you, Judge.
Heather Payne.
On the record, State versus Heather Payne, 23 CR 8584 on for VOP status conference. Attorney Falcone representing Ms. Payne, Attorney Walco for the state. So figure this out. So I've got a note from April 2nd that the case came on for VOP merits. However, defense thought there was an agreement with Chittenden for a global resolution. That is not now the case. Parties request VOP merits be reset for 30 days. However, defendant did not appear today. Request of state and probation and parole. The court directs defendant to meet with her probation officer no later than the close of business tomorrow. Is that the issue here, or was there something else that brings us here?
So I think if I'm reading the portal correctly, I think there was a warrant that issued based on a VOP filed on April 6th,
Okay.
alleging that Ms. Payne did not show up to probation on the 3rd, by the end of business on the 3rd.
Gotcha. Thank you. So I do see that now. So I would, no, we have to do a VOP Rule 5 hearing on that.
Yes.
Thank you.
So we are in receipt of the complaint that was filed on April 6th. We would waive reading of the complaint of Rule 5 advisements and enter a denial.
State looking for any conditions or bail?
Just that the defendant, report to probation.
And I
So
do
we'll-
think that Ms. Payne's, you posted a bail over. Yeah, posted a bail over the weekend, if that could be.
Okay, so strike bail, release her on a condition that she go from the courthouse to probation and parole to meet with her probation officer. Does it make sense to put this on for VOP merits with the other one?
I think so.
Will do. Okay, you're all set. Thank you.
Yes. Yeah.
Have a good week.
You too. Okay, I think that's it for our 1 o'clock block. All right. Probably see you folks at 3. Thank you. You may be seated.
Right here.
Well, we're back to the fixed.
Yeah.
It's.
Is that- Let's see. Good.
This is person before.
All right, good morning, everyone. We are now on the record, ready to start our 3 o'clock status block. We'll do it the usual way. I'm going to call them in alphabetical order, but if you have a conflict such that you need to leave early, let me know. If you just have one case, let me know. And if you have a client in the courtroom and you want to go sooner, it's fine as well. Attorney McLaughlin.
Sorry, yes, taking advantage of the one client rule, Susan Lyons.
On the record, State versus Susan Lyons, 25 CR 95. From Attorney McLaughlin. You could just mute yourself, Attorney McLaughlin, for a sec. Now we have Attorney McLaughlin representing Ms. Lyons, Attorney Bevere representing the state. And my last note says Attorney McLaughlin indicates offers have been exchanged and the state is considering defendant's offer. Parties ask for another status. So.
And that is all still very much true, Judge. I did consider the offer, but I asked for some additional information, which Attorney McLaughlin has since gotten to me. I just haven't had a chance to review that. Another court wants us to do a scheduling order in the meantime, but hopeful that they'll look at that quickly in the next week and go from there.
Well, Attorney McLaughlin, if you want to unmute yourself, I'll hear from you.
Thank you. Sorry if I'm causing the echo. What Attorney Bevere just indicated was accurate. My hope is we're able to resolve it with the information that I just gave him. And if he is able to get to it in the next 30 days or less, then hopefully we have a resolution for you.
Right. Well, it's a September filing, so. I'd like to put it on a trial list if there's one that makes sense. And it doesn't have to be immediately, but I'd like to get down a list. And if you folks reach an agreement, great. If you don't, and you need to do some depositions, give yourselves time to get it done. But
I would say July or August.
Attorney McLaughlin?
Either is fine. Thank you.
Just tire the court.
Yeah.
We'll put it on the July list. See if we can get to it.
Thank you.
Thank you.
That means we're putting you on the July jury draw list, but the attorneys and you are going to continue to talk in the meantime and see if you can reach an agreement. If you can't, you can always do a trial in July. Okay, thank you. You're all set.
Judge, I just have Ms. Rowan.
McGrath, which one?
Tina Roy.
Okay. On the record, State versus Tina Roy, 25 CR 13458. Attorney Groff represents Ms. Roy. Attorney Sun represents the state. So looks like we're going to have somebody stand in for Attorney Sun. Thank you, Attorney Bevere. So my last note from March 9th came on for status conference, no global agreement with Orange County yet. Defense counsel needs time to meet with defendant, reset for 30 days. Attorney Groff.
Judge, I think we are good to go ahead and put an FSO together. I still need to go over the offer with Ms. Roy, but I think we need to keep it moving forward.
Where's the file a felony discovery order within 1 week?
That's fine, Judge. Thank you.
Very good. Thank you. Okay, any other requests before I start with the top of the alphabet?
Judge, I do have one in person, Ryan.
Yep.
Tomorrow.
On the record, State versus John Morrow, 26 CR 1459 and 26 CR 1416 on for a status conference, 25 CR 2880 for a VOP status conference. Mr. Morrow's present with Attorney Davis. Attorney Olson represents the state. Chamberlain standing in. Attorney Davis.
So I think, and I know the court actually reached out about this earlier. I think Mr. Morrow's cases would be suitable for the multi-charge docket because the parties have been discussing, and I think we'll get to parameters for a treatment court referral. Mr. Morrow recently completed residential treatment. He's engaged with probation and things are going well. But I think we want to keep this moving as quickly as possible towards hopefully a resolution and a referral to the treatment program. So whenever the court's able to schedule us in front of Judge McManus, that would be great.
Attorney Chamberlain?
It's fine, Your Honor.
Okay. So we'll ask that it be set as quickly as it can be on the multi-case docket.
Thank you.
I'll let you know. Thank you. You're welcome, sir. Versus Andrew Beal. 11-320 RDCR on for a VOP status conference, 25 CR 4111 on for a status conference. Attorney Falcone is here with Mr. Beal. Attorney Raleigh on WebEx representing the state. So parties have discussed resolution. State needs to speak with complainant. Attorney Raleigh or Attorney Falcone, any update?
I'm happy to provide an update. I did just email Attorney Falcone, who had asked me for an update before now, and I was not able to get her one until just a moment ago. The state is going to dismiss the charge without prejudice and will also withdraw the BOP.
Very good. Thank you. All right. Case is dismissed without prejudice and the VOP is withdrawn. Thank you.
Thank you, Judge.
You're welcome, sir. State versus Charles Biondi. 24 CR 1896 on a VOP status conference, 25 CR 10984 for arraignment. Attorney Davis and Attorney Walco. Looks like we have Ms. Champagne as well for probation and parole. We have Charles Biondi.
So we don't here, although I did not have enough. Well, I wasn't able to reach out to him in advance of the status to address the arraignment portion of this, which is just an amendment, I think, based on an original filing here.
Okay.
So I'm not sure that he was noticed be here in person this afternoon. I have been in good contact with him and in discussing, we'll be able to handle the arraignment, Judge. The parties believe we're close enough to set a global change of plea. And I expect we'll be able to work out the contours of a resolution. We can deal with the amendment when we ultimately hopefully resolve the cases. And speaking with probation, he's been doing much better in terms of his engagement with probation. So things are largely positive right now.
Thank you. Attorney Walco.
Yes, Judge, the arraignment is just based on a filing. And
Okay.
you think we're getting close to an agreement? So I know.
Ms. Champagne, anything to tell the court?
No, Your Honor, Attorney Davis's representation is accurate. Mr. Biondi is doing well on supervision right now.
Very good. Thank you. We'll set it for a change of plea.
Thanks. And Judge, I do see Mr. Pandiani here, who's
on the record, State versus John Pandiani, 26 CR 2163. He's here with Attorney Davis, Attorney Walco for the state. Mr. Pandiani's participation was required today, and he has appeared. Attorney Davis.
Thanks, Judge. So I just need to get a proposed felony scheduling order over to the state. Happy to do that within 7 days.
Okay, Attorney Walco.
Yes, Judge.
Okay, parties file a felony discovery order within 1 week. Otherwise, you're all set. Thank you, Mr. Pandiani. versus Mitchell Bowen Jr. Hello, who's speaking? Right, on the record, Steve versus Mitchell Bowen Jr., 1396-1218. Yes. What's your name, ma'am? What's your name? What's that?
My name is Tina Roy.
Okay, thank you, Ms. Roy. We did your case and the parties are going to file what we call a discovery order, as indicating when they're going to take certain steps in your case and when it's going to be ready for trial. So you're all set.
Okay, thank you.
You're welcome.
Thank you. Thank you.
Bye. Okay, State versus Mitchell Bowen, 1396-1218, 22 CR 10 or 90-81-220, 1800-1013, all on for a VOP status conference, and the new charge is 25 CR 405. Mr. Bowen is incarcerated. His attorney, Attorney Bergman, is on WebEx, as is Attorney Raleigh for the state.
Your Honor, I can give us an update.
A second, my computer is a little slow here.
Okay.
Right now it's frozen up. So anyway, then go ahead, Attorney Bergman.
So the parties have reached an agreement. I am going over to Marble Valley tomorrow to have my client sign the agreement. It will contemplate a contested sentencing. So I'm not sure if we can do a change. Right now, it's currently scheduled for May for the trials, and this will resolve that. And so I don't know if we want to keep on for a change of plea at the pretrial conference or a different date, but I should be filing the signed plea agreement tomorrow afternoon.
Will it be a change of plea and then setting a sentencing out after a PSI, or will it be a change of plea and sentencing at the same time?
I don't think sentencing at the same time, although I defer to Attorney Raleigh.
We haven't really talked about it. I don't think it's been too long since Mr. Bowen had a PSI.
Is it an agreed upon sentence?
No, it's contested, Judge. So I think for that reason, it makes sense to do another.
Yeah. Yeah, I think if it's a contested sentence, that would make sense. Okay, so we'll set it for a normal length change of plea. And we'll take it from there.
Thank you.
Okay, thank you.
Thank you, Judge.
Welcome. Okay, next is State versus Brian Greeno, 26 CR 962, Attorney Falcone and Attorney Bevere covering for Attorney Sun. Mr. Greeno is incarcerated. So March 25th, court granted a motion to suspend bail for Serenity House. That's the last note I've got. Attorney Falcone?
And Judge, so we just modified conditions again late last week, so that Mr. Greeno just discharged from Serenity House today. He is going to be residing at a sober living facility in Burlington. I did make an offer to Attorney Sun, and I'm waiting to hear back on
Oh, we have,
phones.
okay. We have Attorney Sun on WebEx. Attorney Sun.
So Judge, I think we're gonna need to make some more modifications to the conditions. I note that there's a curfew condition with no exceptions. I think we probably need to add some of the sort of basic slate of exceptions for medical treatment, medical emergencies. Legal appointments, court dates. So I think that's certainly something that I think we can probably agree to. I don't know that I wouldn't expect attorney.
The curfew, looks like the current curfew though, Attorney Sun, is 9 PM to 6 AM, so.
Oh,
probably
that's right.
okay.
I'm sorry. That's right. We agreed to, that's right. Okay. So we don't need to do that. In terms of resolution, I am in receipt of the defense's proposal. And am considering it. There's some victim input issues that we need to work through. I would defer to the defense and to the court as to whether this should go on a trial list or whether an additional status conference is worthwhile.
If it's another status, I think we could probably get close to working something out, hopefully.
Okay, we'll set it for one more status conference and we'll send everybody notice. Thank you.
In Your Honor, if I may, I would like to go out of turn.
Yes.
I have just one case and my client, Miss Waters, Reba Waters, is present.
Very good. Right, on the record, State versus Cereba Waters, 26 CR 1926. Ms. Waters is here with Attorney Brooks, Attorney Walco for the state. We are on for a status conference of February filing. Attorney Brooks.
And Your Honor, I do believe this is our first status conference. This morning, the state attorney Walco did provide a plea offer, which I have in turn relayed to Miss Waters. She's going to take some time to think about it before we make a response. Meanwhile, she's also going to come to the office to review discovery with me. I think the state is also going to take the opportunity to review the essential body-worn camera footage in this case. And I think that we may be able to come to a resolution with one more status conference.
Any objection?
No objection.
All right, that's what we'll do. Thank you. State versus Erica Handy, 25 CR 13586. Attorney Davis and Attorney Walco. So just checking, it's 2025 case, but was arraigned on February 2nd. Oh, I'm sorry. It was arraigned on March 2nd. Attorney Davis.
Happy to get a scheduling order over to Attorney Walco and we can follow.
Parties file a felony discovery order within 1 week.
That should be fine.
Very good. Thank you. State versus Winter Holland Levine, 23 CR 5370, Attorney Erlin and Attorney Raleigh. So my last note says defendant, so it was back in November, we had a status conference. Defendant recently sentenced to a long term sentence in sex assault. That's under appeal. State wants to see the results of the appeal before making a decision on this case. Hey, Raleigh, anything to update on this one?
No, I wonder if I'm the person who said that if somebody stood in for me.
I don't, my notes aren't that detailed.
Okay, fair enough. I apologize, Judge. I wasn't,
Yeah.
I don't think I said that, and I'm not suggesting that somebody else was wrong, but either I've had a change of heart or someone else said it. I'm certainly willing to discuss wrapping this into Mr. Holland Levine's current sentence. The appeal has not been filed. There was just an extension for the appellant's brief. And I frankly don't know if there is likely to be any substantive appeal anyway. This is a possession, so I'm happy to talk about it.
Ray Ferland?
Judge, I don't know why, but my camera's not working all of a sudden.
Okay.
Other than that.
That's all right. We can hear you. Okay.
Okay. Well, I'm not sure.
Well, it's a misdemeanor possession of cocaine.
Yeah.
This underlying sentence was 5 years on the sex assault.
Right.
Did you see about working something out on a time served basis?
I mean, I'm willing to try.
Okay. Well, it's a possession of cocaine misdemeanor. Why don't we put it on trial list a few months out and
That sounds
see if you can reach a resolution?
okay.
Okay. What?
I would propose
Makes sense.
either July or September.
Ray Raleigh?
Those are both fine with me.
All right, let's try for July. I'll put it on the July pretrial and jury draw.
Thank you, Judge.
Okay, thank you. State versus Crystal Jerome, 26 CR 374, 369, 213, and 367. Attorney Falcone and Attorney Olson on WebEx. Oh, it looks like one felony, unlawful trespass, residence occupied. Attorney Falcone?
So Judge, the last I was aware, Ms. Jerome was hospitalized. I am been trying to figure out if that's still the case. So if we could reset this very shortly, and I can get confirmation as to whether or not she's been discharged, then I might have a better report for the court.
Attorney Olson?
That's fine, Judge.
Okay, we'll do our best to reset it in about 2 weeks.
Thank you.
Okay. State versus Stephen Kingsbury, 25 CR 2787. Davis and Attorney Polino. Like we did the status conference on March 4th. Discussions are ongoing. Attorney Davis, you want to go first?
Sure, yes. Parties had essentially reached an agreement. Subsequently, the state elected not to go forward with that agreement before it had really been finalized. And it looked like, per a communication that we were having last month, we might move to extend our felony scheduling order deadlines and just go through traditional completion of pretrial discovery phase. I did have a conversation with Attorney Polino on Friday about the parameters of a contested sentencing, where there would be a probation sentence, but the decision for the court would be the length of the split. I need to follow up with Mr. Kingsbury about that. I did speak with him on Friday, but I wasn't able to circle back today in advance of the status about the conversation I had with Attorney Polino. So my thought, Judge, is if we could do another status in 30 days, I think we'll either have an understanding about the parameters of a contested sentencing, or the court may be in receipt of a motion to extend our scheduling order for us to finish pretrial discoveries.
Hey, Polino?
That's fine with me, Judge.
Okay. That's what we'll do. For that reason, we'll set up another status conference in 30 days, see if there is an agreement or not.
Thank you.
Thank you. State versus Les Lanowet, 26 CR 1379, Attorney Falcone and Attorney Walcone. Our first status conference. Attorney Falcone.
Thank you. I recently ordered discovery, waiting on that. I do have a meeting later this week with Mr. Lanowet. If we could come back for another status.
Any objection?
No objection.
All right, that's what we'll do. State versus Troy McClure, that's yours as well. 26 CR 1739, Attorney Falcone and Attorney Bevere.
Is another request to continue. I just haven't had a chance to meet Mr. McClure yet.
Attorney Bevere.
Objection, Judge.
What we'll do. Versus Jeffrey Millette Jr., 26 CR 1378, 25 CR 7943. Attorney Davis, Attorney Sullivan for the state on WebEx. And a note, defendants required to appear. So check to see if we have Jeffrey Millette either here or on WebEx. Not appear as though we do. So there was a status conference on March 2nd. Set for status conference with defendants' participation required. Attorney Davis, anything further to report on Mr. Millette's cases?
No, Judge.
Attorney Sullivan, what's the state's request on these cases?
Yes, Your Honor, thank you. The state's request is that his failure to appear be noted and that an arrest warrant issue in the amount of $5,000.
All right, court will grant that request. Next is State versus Precious Okori, 24 CR 12047. Attorney Vasiliou for Mr. Okori, Attorney Sullivan for the state. So my last note, defendant still incarcerated in Massachusetts in a Massachusetts state case. U.S. Attorney's Office in Rutland will be bringing him back here to face federal charges, which will have some overlap with our case. Not clear yet when this will occur. Reset for 60 days. So Attorney Vasiliou, do you have any update on this one?
I do, Judge. I've been able to have Zoom meetings with my client. I was able to connect with the Hambden County Jail in Massachusetts. So I've gotten no updates from the federal government in terms of when they're going to bring him back. But I've been using the last 2 months or so just to kind of meet with him once every other week to go through all the discovery in the state court case, which tends to overlap with the discovery that I anticipate will be given to me in the federal case. As far as what we do in this case, Judge, I mean, Your Honor could issue, if you want him back and you want us to move along, certainly if the court wanted to issue a warrant and bring him back to state custody, I would be open to that. Or if you want us to just continue on the path we've been on, I can do that as well. I just have no real clarity from the federal government. I know he's charged in federal court. I know they're planning to bring him back at some point. I just, beyond that, have no additional information.
Attorney Sullivan?
Sure. So certainly Mr. Okori ultimately was released on bail and conditions in this case. He certainly wasn't noticed to be here. I recognize the reality that he's in federal custody.
I think he's in, am I hearing it? He's still in state custody.
He's in state, yeah, state of Massachusetts.
Oh, I misunderstood. I thought
sorry.
Okay. So I guess I'm assuming the federal government has a detainer lodged already, but I guess I don't know that one way or another. I'm open to the idea that we set a brief status conference with Mr. Okori's appearance required. And assuming he doesn't appear, the state would request an arrest warrant. Certainly open to that procedure. We'd lodge a detainer and would ultimately seek to return him to state custody to face these charges, barring some other.
Seems to make sense. Did I understand you to say, Attorney Vasiliou, that you think he's got about 2 months left in Massachusetts custody, or did I misunderstand that?
So in January, that was my understanding, Judge. I'm a little confused as to what Massachusetts is doing. I think the state of Massachusetts is also waiting for the federal government to come get him and take primary custody of him.
Okay. All right, so let's set it for a status conference with his participation required, just so that we can get a hold on him regarding our state case. If we can do it in 2 weeks, Megan, let's try for then. Okay, thank you.
Thank you, Judge. And I'll continue to work through discovery with the state judge.
Yeah, sounds good. State versus Travis Pop, 25 CR 7867. Attorney Falcone and Attorney Walco. So I've got a note from March 25th. Case came on for change of plea. Parties had an agreement, but now defendant wants to try for treatment court. He needs to be screened, set for further status conference in 2 weeks with his participation required to ensure he does screen into treatment court. Hey, Falcone.
Mr. Pop is not here today, Your Honor, and the treatment court screening hasn't taken place.
Attorney Walco.
Judge, I want to let you know the defendant's here and feel more.
1,000. Okay, court will grant that request. State versus Charles Rayome, 24 CR 4075. Attorney Davis and Attorney Raleigh. Oh, my last note, February 9th, there are ongoing negotiations. State has made 2 alternate offers. Defense needs to consider, but believe case will resolve. Set for status conference in 60 days. Attorney Davis.
Thank you, Judge. On my own calendar, I didn't see this case on and believe we were circling back around on another week for it, so I apologize for that. I can tell you that it's in the same posture. We're undertaking some evaluative steps that we're in the process of completing now that I'm hoping will inform what treatment by DOC may look like, which is the real question I'm trying to get an answer for, because the different offers contemplate different types of supervision. I think I'll need to check back in with my expert, but I feel like we're very close to completing that. And then I can speak with Mr. Rayome about the offers that are presently on the table. So apologies for not seeing this one for this afternoon, but we are still getting the work done. And if we want to just reset this, maybe even in a couple of weeks or 30 days, I expect that I will have further updates for the court.
Hey, Raleigh.
That's fine with the state.
Okay, we'll try to reset for 2 weeks.
Thank you.
Yeah, you're welcome. State versus Sean Savage, 25 CR 1827, 24 CR 5215, 25 CR 130. Attorney Falcone and Attorney Olson. The note indicates case hearing will be canceled if parties file a felony discovery order. I'm looking at the right one.
Judge, I think it was actually,
Plea by waiver, I'm sorry. Yep.
yes, plea by-
My apologies. If a plea by waiver is filed. Okay, that makes more sense. So this is the case. Defense counsel has confirmed defendant serving a federal sentence in Lewisburg. State will make a concurrent offer set for 30 days, plea by waiver, okay. Attorney Falcone?
And if we could set for a change of plea, we still might be able to proceed by waiver. That has not happened yet due to.
Okay, so the state would have to get a writ or
I
don't
think
know if
there's
they can
still
do
a
it otherwise.
possibility. I think, Judge, there's still a possibility that we could do this by plea by waiver. The defendants, at least what I have in mind is that either the defendant would be pleading to a misdemeanor and it would be concurrent time served if the court is willing to entertain that. I think it's just a matter of getting the paperwork to the defendant and making sure that we nail down the parameters of what he is pleading to.
All right, why don't we set it for a change of plea in 60 days and folks can get the waiver paperwork done? That would be good. Thank you. State versus Joey Sherwood, 25 CR 3642, 21 CR 1667, Attorney Ferlin and Attorney Sullivan. It's like there are active warrants for Mr. Sherwood.
Judge, this is a case where the defendant is incarcerated federally, and I've been trying for months now to communicate with him. I did make a little bit of progress. I found out that he had been moved. I communicated with that new Federal Bureau of Prisons facility. Sent them, I got the instructions on how to arrange a telephone conversation with him. I sent the fax, but did not get a response. So I'm just gonna have to try to do that again.
Okay. Attorney Sullivan?
Yeah, I think my recollection of where we're at with this status is that the state has conveyed an offer to resolve. It sounds like it's a type of offer that might result in resolution. And ultimately, I think the state is looking for feedback from the defense, whether we are going to set a change of plea hearing and get a writ to bring him back from federal custody for the purpose of doing a change of plea, or if this case is going on a trial list and we'd written him back for a jury drawn trial. Certainly, if we're doing a jury drawn trial, having specific dates from the court makes drafting a writ the federal government will comply with much more straightforward.
Right. Well, we're set right now for a change of plea hearing on June 16th at 10 a.m. So
I think we should keep that scheduled, Judge, and I'll keep trying to get in touch with him. And if the court wants to set another status in approximately 30 days, hopefully I will have made some progress.
okay. All right, we'll do that. We'll set another status conference in 30 days and keep the change of plea on for June 16th. Thank you. State versus Kevin Simmons, 26 CR 1841, 25 CR 11472. Attorney Davis and Attorney Enzor for Mr. Simmons. Attorney Pavir represents the state. Mr. Simmons appears to be incarcerated.
Mr. Simmons is the gentleman who's facing serious charges out of Bennington. His jury draw there on those cases is scheduled for June 2nd. I think we had talked about possibly rescheduling this to see what happens with the Bennington case. Just
Attorney Enzor?
Judge, just a fine suggestion. I think I have the 2025 docket. Is that correct?
That is correct. Aggravated assault.
So I'll defer to the court, whatever the court wishes to do. There have been no really substantive discussions about resolution, but I know the court wants to keep things moving. So whatever the court wishes to do, I'm fine with.
Mary Davis?
Yeah, if we just want to status the 2026 case at the next event and then the 2025 case, I'm fine with that. In the 2026 case, I just need to review whether there's a motion issue that would form the basis for a motion to dismiss, and I'm happy to do that hopefully before we come back.
Okay. All right, looking at the notes, the Bennington case is attempted murder.
That's correct, Judge.
Okay. So it probably does make sense to wait and see, at least till after June 2nd, see what happens. So we'll do another status conference, maybe the later part of June. Versus Brandon Staples, 26 CR 2165, 26 CS 212, Attorney Davis and Attorney Chamberlain.
Happy to get a felony scheduling order over to Attorney Chamberlain within 7 days.
Works, Your Honor.
Okay, parties will file a felony discovery order within 1 week. State versus Joseph Tardif, 25 CR 12185, Attorney Falcone and Attorney Sun. Mr. Tardif is present, which he was required to be here based upon his conditions of release. Attorney Falcone.
Thank you. 1 second. Judge, I think probably at this point it makes sense to do a felony scheduling order, but I would ask the state if they have an offer. Be happy to review it.
Okay, Attorney Sun.
I can certainly make an offer, Judge, and I'm happy to review a post felony step.
Okay, parties will file a felony discovery order within 1 week, and the state will also make an offer to the defense. Thank you. State versus Jordan White, 25 CR 13224, Attorney Ferlin and Attorney Sun. Like we were waiting on a felony discovery order. Folks have something different to report, or do you need to get us a felony discovery order?
Judge, the state attorney Sun did make forward a proposed offer today, or not a proposed offer, an offer. I have not conveyed that to Mr. White yet. So I will do that if it doesn't result in a plea agreement, then we'll file a felony scheduling order.
Okay, all right. Attorney Sun, parties will file a felony discovery order within 2 weeks unless you notify the court that there's an agreement.
Makes sense to me, Judge.
Okay, that's what we'll do. Thank you. Looks like that's it on my list. Anybody else see anything? All right, have a good evening, everybody. We will be in recess.
Thank you, Your Honor.
Thank you.